preliminary matter that I would request a favor from the court. I have an associate with me, Miss Emily Schiller, former clerk of the Western District, former federal clerk in the Western District of Kentucky. I'd like to have her argue today, but as a training thing for her, but if something comes up that requires historical knowledge of the Tennessee Democratic Party, because I've been the general counsel for so long, I would ask that I would be allowed to deviate from the normal rule and respond to that if it does come up for some reason. Otherwise, I have no intention of speaking.
Is she a member of the Tennessee Bar?
She is, Your Honor. And I've spoken with opposing counsel, and he has no objection to it.
In that case, we have no objection.
Thank you. I don't believe it'll arise, but just in case if it did, I want it to be covered. Thank you.
Yes, sir.
May it please the court, Gary Blank of the Nashville Bar. On behalf of the plaintiff appellants, I'd like to ask for 3 minutes of rebuttal.
Yes, sir.
Democratic Party has a long history, going back to Andrew Jackson. So, and I'm sure the learned counsel is aware of that history. But this case is pretty simple. This has to do with the authority of someone who's not elected to the State Democratic Executive Committee to vote, to cast a vote on any matter. What happened was that there have been customary concessions made to people referred to as ex officio members. And those persons have in the past been allowed to cast ballots, to vote. This has created some controversy. It culminated in a decision made by the committee to allow high school children, I call them because they are children, to vote, to be members and vote. So this created a big brouhaha because these children weren't even allowed to vote in the election for the people they're serving with, or any other election. That occurred, and there were 14 or 15 of the members who voted against that. Some of those persons then brought this lawsuit. The issue that has been raised below is that there was a case, which I'll discuss in a moment, that said with regard to the imposition of the open meetings law, the sunshine law on a meeting, that applied to the committee when it's set as a primary board, but not when it's set as an executive committee, and that there was no prohibition against ex officio members. Respectfully, that misses the point. The point here is not whether they can do something that the law does not specifically forbid, it's whether they have an authority gained from some source other than the General Assembly. The case that was cited did not have to do with with voting power. It had only to do with whether the open records law applied to it. So,
counsel, doesn't it go a bit beyond that? I mean, it's viewing these as two separate entities, isn't it?
Yes.
Newsom case.
That's how the trial judge looked at it. But
isn't that how Newsom looked at it? Isn't that how the Tennessee Supreme Court understood it in Newsom? These are essentially two different, distinct entities.
Well, they use that term, but the two entities are created by the same statutory source and have the same requirements for participation. They're saying there was a specific provision cited by the court that said the open records law applies to primary boards. That's what they were trying to talk about. But the primary boards are the same individuals that are on the committee, the executive committee. So if we go to TCA 2-13-102, this creates the executive committees for both parties. It could create executive committees for any number of parties, but there are two that this really spoke to. It says each political party shall have a state executive committee, which shall be the state primary board for the body. And it says in section B, the state primary board shall perform the duties and exercise the powers required by this for the party. Now, the primary board can take various actions and certify candidates to be on the ballot. The question of whether that person is a bona fide, is an actual Democrat or Republican, is for the committee itself, the same individuals. Section 103 says members, and I respectfully submit that the most important word in this case is members. Members of the State Executive Committee for each party are elected at the regular August primary election immediately before the election of governor. And Section B says, in each party's primary, its voters in each senatorial district shall elect one man and one woman as members of the State Executive Committee for terms of 4 years beginning September 15th.
So is the implication of your argument then, the government controls who can be a member of a party executive committee?
It only
That's solely within the control of the government?
well, to the extent of how they're selected, how they're elected, yes. Because the statute specifically says how members are selected.
So if the state were to pass a law that said the executive committee must always include one Republican, they could do that?
Well, that raises entirely different issues because of the First Amendment. But
Yeah, I'm just wondering about that. That seems to me be a natural implication of your argument, to say, well, the state executive committee can look no further than what the state statute says in terms of membership. And if that's the case, what happens to freedom of political association under the First Amendment? I mean, it seems like to me you really don't have any freedom because it's the government that determines who the membership is composed of.
no, it's the people in the senatorial districts who vote for the candidates and select the members. They're the
Well-
ones who determine it. That's the association they are seeking.
Right, the statute currently provides that, but, I mean, under your theory, I'm presuming that the statute could be modified in any number of ways to change that membership, though.
Well, certainly it can be modified to change the membership. They could change it to House districts rather than senatorial districts, for example. But the intent, obviously, is that from the public, for those who seek the office, one man and one woman for each senatorial district must be selected. If you're just going to allow the committee to choose whomever they please, then they can, and they have done this, they can ruin that proportion, of men to women. They can just change it as they please.
So is it your position then they're always going to be limited then to what the statute says in terms of their composition, their membership, always limited to by that statute?
Well,
So they can
always
never
is a
have.
big word, but yes, essentially.
Right. So, I mean, for example, if instead the party wanted to make, they said, well, instead of having one each, we're going to have two each, and instead of selecting by primary, we're going to say, whoever's the biggest donor in a particular precinct will get a spot on the executive committee. They couldn't do that under your conception of how this works.
I don't know, they couldn't do that under the statute which they enacted.
Yeah. Okay.
But what this statute does is not control any aspect of speech whatsoever, or any aspect of association. What it does is set up a set of standards for how these people are selected, and they're selected by the people from those who stand for office. That's what's being done. Now, remember, the State Executive Committee presently on each party is created by statute. These are not associations. These are not, years ago, there were questions raised about parties in certain states having racially discriminatory policies and selecting themselves, selecting one another. We don't have anything like this because it's determined by the people.
Yeah, well, who determines what powers a state executive committee? I mean, the statute determines what power a primary board has, but who determines the power of the executive committee?
The executive committee essentially
What roles they perform? I mean, you talked about them deciding who was a bona fide member of the party, for instance, was one thing. I mean, who makes that determination? Who gets to decide that?
the committee itself, not the primary board. That was clear from the
And only the
case.
committee itself, so only those people designated by statute can make that determination, no others.
Well, and elected, because the statute says that the way they are elected is they stand for the office, and then they're required to take an oath, and then they're required to send these certificates then to the state coordinator of elections. If they don't do that, they're not members. They're never sworn in as members. The legislature, I'm not here to praise or criticize their scheme. I'm just here to say that's what it is. They say how this is done. If it weren't for this, you could have some sort of rogue management that decided that here's an issue that we feel strongly about, and we have some people who are recalcitrant. So what we're going to do is we're going to select 70 ex officio members and give them all a vote. They can't vote on the primary board, but they could vote on everything else.
Counsel, the trial court judge in this case didn't make the determination based upon the constitutional question or even constitutional avoidance principles, right?
That's
this
correct.
Decision is just a matter, from the trial court, is just a matter of statutory interpretation.
What he said was that the committee, that there isn't any statute that prohibits selecting ex officio members and giving them a vote.
But he doesn't apply, he in the last
Doesn't
portion
reach
of
it.
the order, he essentially says, I don't have to get into the constitutional issue. It could be a violation of the Constitution, but I don't have to go there because the statute, he doesn't read the statute as imposing the restriction that you do in this case, right? It never reached the constitutional issue.
He just says it doesn't say they can't. But my insistence, respectfully, is that it doesn't say they can. And this is an entity that is created by statute, that exists only because of the statute. Now, the organization of young Democrats, young Republicans, and all of these that we've seen over the years are voluntary organizations. Their freedom of association is guaranteed by the First Amendment. This is not one of those organizations. This organization, the executive committee can have significant impacts theoretically. Many years ago, in a different era, the Democratic State Executive Committee selected the candidates for the Supreme Court of Tennessee. That's how we had the late, great Joe Henry as a Supreme Court justice. They selected them because of some anomalies that occurred. So it can be important. For the most part, it's important to those who are concerned about these issues, I suppose, but there's not many practical implications of it. But how can you, under the bylaws, the Democratic Party, the chairman of the party can vote to break a tie, but in no other circumstance. The reason? Because he or she's not an elected member of the committee. So if the statutory scheme is you can select whomever you want, you can select a person who others may think is unqualified or whatever it is, or highly qualified people, but you cannot select people without being elected, because this committee has a scheme set by law that permits their participation. Thank you.
Thank you. You have your rebuttal time.
Thank you, and may it please the court. The issue here is really simple. The question is only whether the executive committee has the right to elect ex officio members and allow them to vote on executive committee matters. Appellant has sued only the executive committee. The primary board is not an issue here. The executive committee and the primary board are two different entities.
Counsel, let me ask you about that. This is 213-103A provides members of the state executive committee for each party are elected at the regular August primary election immediately before the election of the governor. That sounds like that's how members are determined and elected. It sounds exclusive in nature in terms of how members are chosen. And then primary board members are chosen out of taken from that group. So isn't the statute pretty clearly saying executive committee members are determined through this election process?
The statutory scheme only limits the selection process for the primary board. There's no limitation, and there's no alleged limitation on electing, statutory limitation on electing executive committee members.
Ex officio members of a committee are members of the committee, right?
Of the executive committee.
Right, so ex officio members of the executive committee are members of the committee, and 213-103A seems to spell out how you determine who members are. I'm struggling to see how, there's a whole constitutional issue lurking here, but in terms of the text of the statute, I'm struggling to see how we get to the idea that members are chosen through some other process other than election, given the language of A.
I think it's easily visualized in terms of a Venn diagram. There's primary board and executive committee, and there's overlap. The primary board members are coming from the executive committee, but the executive committee can be larger than just the primary board.
If the statute's specifying that, where am I putting aside the constitutional question, again, I see that constitutional question lurking there. I've got serious concerns about that, but in terms of the text of the statute itself, where is the authorization to have members that are chosen through some other process? I mean, members of the state executive committee for each party are elected at the regular August primary election immediately before the election. Doesn't say the non-ex officio members of the state party. Is what's driving the silence analysis in this case the constitutional concern? That's part of what I'm trying to get at here.
I believe that's an astute observation. I'm trying to think through your question and make sure that I'm answering it fully.
Well, I'll tell you where I'm going to go next with it, and that may help in terms of, was any notice provided in this case to the Tennessee Attorney General's office? And was the Attorney General provided any notice here in relation to this suit?
Not that I'm aware of, Your Honor.
And there's a counter claim that's raised here asserting unconstitutionality of the statutory provision. And did notice need to be provided here to the Tennessee Attorney General's office?
I am unsure of the answer to that, Your Honor.
Wait, I couldn't quite hear.
I'm not sure of the answer to that, Your Honor.
Well, under Rule 2404, when the validity of a statute of the state or administrative rule or regulation of the state is drawn in question in any action in which the state or officer or agency is not a party, the court shall require notice to be given to the Attorney General specifying the pertinent statute, rule, or regulation. It seems like it's being drawn into question here, and maybe I'm wrong about that, but it seems like in terms of that we've got a question here in terms of the constitutionality of this statutory measure. If so, doesn't 2404 say that notice needs to be afforded to the Attorney General?
I agree with that analysis.
And if so, and are we essentially jumping the gun, so to speak, in this case with resolving it without involvement of the Attorney General's office? And is this a case that needs to be remanded back to the trial court to give appropriate notice to the Attorney General's office?
I would say no, because for a simple reason, which is the question at issue is whether the statute allows something that is not written into the statute. So the appellant says that statute doesn't say that this is in it, right? But statutes don't take away rights by silence. And so if they're challenging the constitutionality of the statute, then I think we're looking at a different question than whether the silence of the statute prevents the party from doing inter-party matters. I mean,
how is the statute silent, though? And members of the state executive committee for each party are elected, and that's not silence. That's telling us how members are elected, or how they're, I guess, selected. It doesn't seem. It seems like that's exclusive.
I'm thinking about your analysis. I think that it is not exclusive, for one thing, because the party has always appointed members.
Yeah, but doesn't 102 make it exclusive? I mean, if you look at 102A, it says each political party shall have a state executive committee, which shall be the state primary board for the party. So there, the statute uses the word shall be. But here, the Democratic Party has created an impossibility. You have an executive committee that can't be the state primary board because you got ex officio members. And 103 tells us that unless you're elected, you can't be part of a primary board. So you got 102A saying shall be, and then 103 has to be elected. To me, read together, that ends up telling you you better not have unelected members of the state executive committee.
I think you better not have unelected members of the state primary board.
Which is the state election committee, or state executive committee.
It's made up of members, I'm sorry.
Under 102A.
It's made up of, the state primary board is made up of members from the executive committee.
Maybe I can address the question that you're raising. Historically, the way the executive committee has handled ex officio members is they have not been treated as if they are the statutory members of the executive committee. So they don't go through the elections, but they are allowed to vote on the intra policies. For example, do we do fundraising dinners?
And so is all that, so this was decided on a judgment on the pleadings. Is all that in the pleadings, or is this additional fact information that really we needed to know before making a determination here?
That information was not part of the record in the trial court. What was put forward in the trial court was, first of all, the fact that the plaintiffs were prior ex officio. One of the plaintiffs was a prior ex officio member and had voted on Democratic intra-policy issues for the party when he was an ex officio member, and that he didn't challenge it until they appointed people he didn't like or didn't want to be ex officio members. But the party has always operated, and this was not part of this was kind of discussed, but it wasn't the focus of what people were looking at the time. The question was, did the statute prohibit the Democratic Party, the executive committee, from having an internal rule that they could then vote as to whether they wanted to add ex officio members, which would not be full members because they would not have the right to sit as the primary board, but they would be able to vote and to weigh in on policy decisions and political decisions of the executive.
Back to my question then, how does that work with 102A then? 102A is the provision that says each party shall have a state executive committee which shall be the state primary board for the party. I appreciate the concept that those are serving two different functions, but the statute read in conjunction with 103 there seems to suggest, as the plaintiffs here have argued, that you really can't have ex officio members under our statutory scheme.
Well, and here's where I disagree with that, because they say first you have to elect the executive committee. That body is then created by statute. That body then adopts its governing rules as to how it operates. And one of the things that it adopted was, we're going to have certain ex officio members. And that was something that they as a body voted on and agreed to and have been in place as long as the executive committee has existed in Tennessee. And those members are ex officio members, which are separately laid out in the bylaws because they are not full members that sit as the primary board.
Counsel, how doesn't that run afoul, though, of 213-103A, which specifies how members are elected? And so the committee decides, well, we really want members chosen in a different way, isn't 103A laying out how members are elected to that committee?
Right, and full members, which are, because when you look at it, there are members and then there's ex officio members. It's like a different class.
Ex officio member is a member. I mean, it's just a member who's be gaining their membership by some sort of status, some sort of title that they have. They're the president of the college Democrats or
Right.
the high school Democrats. And they're still a member of the committee, even as an ex officio. They're just coming at it by their status.
Well, but the difference would be because they don't go and sit as the primary board. When the primary board is convened, they are different than a true member as defined under the statute. So this is no different than like if the legislature were tomorrow.
Yeah, and I guess, but I'm sorry to interrupt, counsel, but that says to me then that the party violates 102A then by not setting as the full executive committee when they're operating as a primary board. But
Right, and the way that conundrum is avoided is because they're not full members. And for example, when you go through an election, someone runs, they get picked for it. But the way the ex officio works is to bring in diversity of opinion and thought from across the state in a way that wouldn't be
yeah,
represented.
I'm not debating the policy. I'm just
Oh.
I'm just trying to concern myself with what the statute requires in this
Yeah.
case. I mean, it may be an excellent policy, and for purposes of this argument, maybe we can all concede that it is a good policy. Well, Mr. Blackburn, I don't want to include you in that, but you're not going to concede that. But just for the sake of argument, we can assume it's good policy to do that. Does it square with 102 and 103 is what we're struggling with here.
So what it comes down to then, Your Honor, is the question of does the committee, once it's been formed by statute, have the ability to govern itself and to decide how it's going to operate and who's going to be involved with it?
Counsel, you raised some very interesting constitutional questions with regard to this below in terms of interference. But going back to Rule 2404, isn't this a case where we've gotten ahead of things in terms of the trial court's gotten ahead of things with regard to you have a challenge to the constitutionality in terms of your filings in this case, asserting that the measure is unconstitutional? Wasn't the Attorney General need to be brought in under 2404, and then can have a whole discussion about whether it's unconstitutional, whether constitutional avoidance lends support to your argument in terms of, isn't this something where the AG really needs an opportunity to engage in this case? Because one of the potential outcomes here is that the statute is unconstitutional, in which case it would clearly be a problem under 2404. But even your constitutional avoidance argument seems to put it at issue in the case. And is this something that needs to go back to the trial court with proper notice being provided to the AG?
Your Honor, I think it definitely probably would have been better if we'd have had the AG involved down at the trial court to begin with. I will say that the one thing that Mr. Blackburn and I have been able to completely agree upon in this case is we would like finality, and remand does not lead to finality immediately. So I understand where the court is going, and I would agree that had that occurred down below, we would be in a better posture to address the constitutional stuff now with the AG weighing in. And if the court's decision were to remand to have the AG weigh in, you certainly wouldn't have me complaining that this was an overreach by the court. But we also would like finality, and we believe that the decision, the way it was crafted by Judge Briley, avoids the constitutional issues and just says that the party has that ability to make the decisions once they've been empowered, by statute. And we think that means you don't have to reach any of these further issues. Because our real argument on the constitutional stuff was, if the defendant's argument is accepted and the statute is interpreted that way, you invite this entire mess that we're talking about of constitutional issues. But if you accept our version of how the statute should be read, then you avoid all of them completely. And so that's why we've advocated the way we have. But if the court thinks we need to get into those constitutional questions, then I do believe that it probably would be better to go back and have the AG weigh in. As much as that pains me to say that.
Thank you both. That
Thank you.
concludes your time. You have your rebuttal, sir.
I think Your Honor is correct about the requirement of notifying the Attorney General. That wasn't done in this case. No constitutional issues have been determined in this case. There was some discussion about freedom of association. We could have had some discussion. I spent a good bit of time this morning. This is the only time in 52 years I've had 2 arguments in the same day. But one of the things I was defending was whether I had notified the Attorney General soon enough, whether there was some waiver for me not notifying the Attorney General soon enough as to that particular statute. So, and these facts that counsel is raising are not in this record and were not determined and not discussed. One thing that I would point out is how are vacancies filled on the executive committee? That's also determined by statute. 213-105 says each state executive committee may, by vote of its members again, temporarily fill a vacancy in its membership due to death, resignation, disqualifications, change of residence, persistent absence from meetings without good cause, or violation of the oath of office until a successor is chosen at the next regular August election. Well, that means if there's a vacancy, it's a vacancy of a member, and there is a specific means for replacing that person, and it includes an election.
Counsel, if a secretary, so you've got the statute 106 addresses secretary and chair, right? And so if a secretary is chosen who is not a member of the executive committee by election, is that secretary a member of the executive committee in some capacity, some form?
No, Your Honor, and I, again, this is not the record, but I did serve a term on the state executive committee, and we went through these things, and no, the secretary does not have to be a member, but the secretary has no vote. The president, the chair of the party.
And that's on the executive committee and the primary board, or just?
Yes, the primary board is the state executive committee serving in a particular function for a particular reason. It's not any different, it's not other people. Now they can bring in people and they can call them ex officio, and they can allow them to speak, to discuss issues and so forth if they choose to do it. That's the associational issue. But they haven't done that. They've made these people members by ignoring the means by which members are selected pursuant to state law. That's our position. Thank you, Your Honor.
Thank you. I want to thank both sides for your presentation. Your case has now been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. The lawyers may be excused.